mbali kesi iliyowasilishwa na bunge la kitaifa kupinga madai ya baraza la magavana kuhusu mgogoro wa ugavi wa rasilimali. Mahakama hiyo imesema kuwa itasikiliza ombi la magavana kutokana na umuhimu wa kesi hiyo. Sasa uamuzi kuhusu kusikilizwa kwa kesi hiyo utatolewa tarehe 16 mwezi huu wa Oktoba. Magavana waliwasilisha kesi mahakamani baada ya bunge la kitaifa na bunge la seneti kutofautiana kuhusu kiwango cha fedha kinachofaa kutolewa kwa serikali za kaunti. Hata hivyo, mabunge hayo mawili yalikubaliana kutoa mgao wa shilingi bilioni 316. Hebu tusikilize hali ilivyokuwa mahakamani hapo awali.
Filed a notice of preliminary objection on the grounds that A, the applicants seek an interpretation of various constitutional and statutory provisions, matters falling within the High Court of Kenya's jurisdiction. 2, that the issues raised in the reference are subject of pending proceedings before the High Court of Kenya, namely A, Nairobi High Court Petition number 277 of 2017, Wanjiru Gikonyo and Attorney General and others. B, Nairobi High Court Petition 252 of 2016, the Council of County Governors versus the Attorney General and others. And 3, Nairobi High Court Constitutional Petition number 284 of 2019, the Senator of Kenya and 3 others versus the National Assembly of Kenya and another. That the county governments have not exhausted the mechanism set out in Article 189.3 of the Constitution of making every reasonable effort to resolve any dispute before resorting to judicial proceedings. And finally, that the applicants have not demonstrated that they sought the advice of the Attorney General as stipulated under Rule 41(4)(c) of the Supreme Court Rules 2012. In response to the PO, the applicants filed submissions, and the other parties herein also submitted on the question of this court's jurisdiction. We note that the question of the revenue to be allocated to counties for the financial year 2019-2020 was settled by a joint mediation committee set up pursuant to Article 113 of the Constitution, and so the issue of an impasse in the revenue allocation is now moot to that extent only. We have noted and framed the submissions of the Speaker of the National Assembly, the submissions of the Attorney General and the Cabinet Secretary to the National Treasury, the submissions of the Speaker of Senate, the submissions of the Commission on Revenue Allocation, the submissions of Katiba Institute and the Institute for Social Accountability, and I will not read through them at this time. You will see how they have been captured when you receive copies of this ruling. The prime issue for the determination at this stage is whether this court has jurisdiction and whether it should exercise and render an advisory opinion as sought. The National Assembly's main argument in the PO is that this court has no jurisdiction to entertain the reference as filed. In that regard, we note that the court's jurisdiction to issue advisory opinions is anchored in the Constitution as Article 163(6) stipulates, and further, on this court's jurisdiction to offer advisory opinions, the Supreme Court Act 2011 provides in Section 13 as follows, quote, an advisory opinion by the Supreme Court under Article 163(6) of the Constitution shall contain reasons for the opinion, and any judges who differ with the opinion of the majority shall then give their opinions and respective reasons. Furthermore, the rules of the Supreme Court provide for the exercise of this jurisdiction, stating that the national government, a state organ, or county government may apply to the court by way of reference for an advisory opinion under the Constitution. In several of this court's decisions, we have emphasized that the exercise of this court's jurisdiction under Article 163(6) is discretionary, and only deserving matters will justify the exercise of this jurisdiction. In the matter of the principle of gender representation in the National Assembly, we did observe that only in a truly deserving case will justify the court's advisory opinion, as questions amenable to ordinary litigation must be prosecuted in the normal manner.